from ALLS.
Thank you. Thank you very, very much to my colleague, my learned friend, Mr. Shehu. I'd like to follow the protocol that was observed by my brother, who just spoke just now, President Akaladi, and recognize the special honor of having the Honorable Justice, Bibi Kanyip, the President of the National Industrial Court of Nigeria, and the distinguished judges of the same courts that are present. I think it's a huge honor, and you're really setting the bar very high to Ilan. And then I will acknowledge all other important guests, dignitaries, learned colleagues from Nigeria and from beyond. And I would just like to welcome you to this webinar series on behalf of the African Labour Law Society. The African Labour Law Society has been in existence for about 8 years. And it was really established out of the realization that we are not having enough conversations as Africans about labor law. And that when it comes to the global world of labor law, we really don't hear the voice of African labor lawyers because we're not having conversations amongst ourselves, as is the case in Europe, in North America, and in other parts of the world. So the African Labour Law Society brings together labor lawyers from across the continent. And one of our objectives also is to deepen the engagement of labor lawyers through supporting the establishment or strengthening existing labor law societies or labor law associations. And to date, we've given birth to one, which is in Lesotho. And there are a few others that are in the process of being of coming into existence. And we are really proud and excited to welcome and to have in our midst, in our family, the Employment and Labor Lawyers Association of Nigeria, which I could say maybe to continue the metaphor we have adopted because it was existing before we were able to bring that about. And we found that this is a society that is very vibrant, it's energetic and thriving, and doing many things that really we hope to be able to be proud of in Africa. And I think the topic here is a very important one, not only in Nigeria, given the circumstances that have happened within the labor law system, but also in Africa, across Africa, because what we find is that there are few universities that are really going deep into this topic and into this subject. So we've invited members from across the continent, and we are hoping to really have great engagement. And we thank you very, very much for this opportunity to host this webinar, and we hope that we'll remain engaged. Thank you very much.
Thank you, Dr. Bamu. I will now pass it on to the representative of ILO, Mr. Bashman, for a few remarks before we get into the proper presentation.
Yeah, thank you very much, Shehu. I was thinking you say the representative for all, because I'm both a member of ILO, ELAN, and even African Labour Law Society. But just to stay aside, I think Jamie and my sister have made my work very easy. As a young lawyer, I always have problem with protocol. But now I think they've established the protocol. It's just for me to just rest on it. And also to mention that my tax is very, very simple. I'm actually standing in for my sister from Kenya. That's Wamai, the regional coordinator of ILO Sub-Saharan Africa. So to keep it simple, the ILO is a project of the Solidarity Center. And the Solidarity Center itself is a US-based international workers organization. And we are affiliated to the AFCIO. So our mandate is to advance workers' rights. And the ILO is led by our director in the Rule of Law Department, that's Jeff Vaux. He is assisted by Monica. Why, as I mentioned earlier, Wamai Jacqueline, she is the regional coordinator for our activities in Sub-Saharan Africa. So basically, like the two sister organizations, ILO is also a labor supporting organization, just that we are a bit more specific and intentional about what we do. we are pro-worker. We are not apologetic about it. So we advance workers' rights, and we do that through the assemblage of labor, lawyers, academia. We've been in existence. This is our fifth. We are actually celebrating our 5th-year anniversary, and we're also celebrating a milestone of over 1,000 membership across the globe. So Jamiu already said that this is a tripartite or international tripartite arrangement. But I still want to say that if my Lord will permit, this is a mini ILO conference, because we are tripartite in the sense that we have persons advancing the cause of the employer, the labor. I'm not sure of the government side, but I think my view is that this learning session will afford opportunity to advance labor law to the students, and importantly, advance labor right. So I'm not to talk too much. I've done my bidding. I'll hand over the brief to Shehu. Thank you very much.
Thank you very much. Before we commence the webinar proper, I will just say a few more words in introducing our lead speaker. So Dr. Mohammed Mwamazingo is trained as an economist, obtained a doctorate in economics from the University of Sussex in 1995. He has worked with the International Training Center of the ILO and was there until July 2022. He's worked in various offices of the International Labour Organization, particularly the Bureau for Workers' Activities, and has worked in various duty stations in Abidjan and in Addis Ababa, in Harare, in Pretoria, as well as in the headquarters in Geneva. He's held various portfolios, including regional specialists on workers' education, as well as the position of senior economist and at the regional desk for Africa. So I will hand over to Dr. Nwamazingo, and let's listen to the presentation. Thank you.
Thank you so much, moderator. I just want to confirm if you can hear me clearly, please.
Yes, we can hear you and we can see you.
Okay, perfect. I feel very much honored to the various organizations that have brought us here together. I wish to bring you special greetings from East Africa. I'm currently sitting in Nairobi. As the moderator said, having retired from active working life just about 6 months ago, is still a learning process. Many of us who have come from the academia, we don't really retire. We probably just take another role. And the invitation to this inaugural meeting of ELAN in the context that has already been described is one of those ways and means of us working together. So a lot of appreciation to ELAN, to ILO, to the Africa Labour Network, as well as to the senior judges, our honorables, and our lords who have joined us here together. Now, I was asked to make this presentation. As much as I'm not a lawyer, having spent 25 years at the International Labour Organization, and particularly dealing with the same issues that we are dealing with today, I had no hesitation whatsoever to make an introduction to the ILO and to the International Labour Standard System to our legal experts today. This is something I've done many times over, basically to trade unions around the world and in Africa in particular, but also to employers and government entities in a number of times. So I felt that it's not much of a difficult situation addressing ELAN and ILO in this particular context. So colleagues, I'm not so sure if you can see my screen. Please confirm. I was fiddling with my computer earlier on, and I realized some things weren't moving as smoothly as they're expected.
We can see your screen, although it's not in the slideshow mode. So maybe if you can get it.
Okay, let me try to do that one more time. The problem is using different computers for different things is that, what
Uh,
about now?
Yes, you have it now in the slideshow mode. Thank you.
Okay. Colleagues, I know I have only 30 minutes to make this presentation. I want to confirm to my moderator and to all of you that I will indeed stop at the 30 minutes level. I may not have finished my presentation, but I know time is always not on our side, and it's not so much the length of my speaking, but probably the questions and answer session that will come at that particular level. So knowing these constraints, I divided my presentation into only 3 parts. One is to introduce the ILO. Two is to bring forward the subject matter of today, which is the international labor standards. How are they formulated? When are they formulated? And whom are they applicable for? And finally, it is to talk about the ILO supervisory mechanisms. And I'm glad that one of our senior panelists today is actually a member of a special committee of the ILO, part of the supervisory system as well. So we are going to interact in that particular manner. Now, the ILO, by the way, many times people think that they know ILO too well, but in an ordinary situation, even if my director general or my former director general listens to me, they'll always get some new information from a presentation of this nature. So colleagues, just bear with me. If you know some of the issues, you may not know some others just because of the length of time we have spent in discussing this particular issue. So ILO, the first specialized agency of the United Nations, having joined the UN immediately, it was founded in 1919. This is very critical because it's probably the only organization that survived the chaotic era of the First and Second World War. And this is important because largely of its mandate, that of social justice. So its capacity to be able to look at economic and social justice for the world has enabled it to survive a number of hectic moments that have surrounded the world. This includes recent events such as COVID-19, such as the fall of the Berlin Wall. Many people thought probably organizations such as the ILO will have run its mileage and therefore could disappear. But it's for the same reasons that we have the ILO as we know it today. Now, the ILO is composed of 187 member states. The newest member is the Kingdom of Tonga, a very small state of just about 100,000 people. So for us in Kenya, or for those in Nigeria, that population does not even belong to a village. But in the context of the ILO, is still a member state. Now, Nigeria is a key member of the ILO. One of the very first countries to have joined this organization after gaining our independence. So I put there that Nigeria joined the ILO on the 17th of October, 1960. Later on, I'll tell you that Nigeria was the first country to host the ILO on the continent by its office in Lagos. This was well before the current regional office was formed in Abidjan and eventually in Addis Ababa as well before returning back. The ILO has actually been awarded the Nobel Peace Prize, just to tell you where it is situated as such. This was 1969, mainly because of its mandate of social justice, but largely because of the stand it took to the elimination of apartheid in South Africa. So a very critical stage in the times of our organization. Now, what is the constitution of the ILO? What is the underlying statement of the ILO? We are saying universal and lasting peace can be established only if it is based upon social justice. And you can recall that these are the words I was using earlier on that have made the organization survive the hard times of it. As it was valid in 1919, it's still valid in 2024. Now, ILO is the only organ of the United Nations that has a tripartite structure, the only organization of the UN that its meeting is not valid unless it's composed of three parties in any given state. These three parties are workers, secondly is government, and third is employers. So there's no other institution of the United Nations that joins this particular issue. So truly, whatever is undertaken must be in the context of a tripartite nature, not only in technical meetings, but also in legislative meetings as well. Now, the ILO operates in two ways in terms of assisting its members. One is standard setting mechanism, and this will constitute a larger part of our discussion today. Secondly, through technical cooperation. So ILO has many offices around the world with the aim of assisting particularly developing countries to achieve social justice and its four strategic objectives, which I'll mention shortly. This technical cooperation is done through information sharing, holding of tripartite and expert meetings. We do have a very competent research element in the ILO, as well as expertise in all subjects in the world of work. Now, I will skip some slides, Chair, purposely because, as I said, there is a lot of information to share with our comrades here, but we don't have that much time. So when you see a slide and I pass it like this, it's not because it's not important. I'm sure this presentation will be shared, but it's basically because of the time that is not with us today. Now, if you want to understand the ILO better, it's nice to look at the top organs of the organization. And the supreme organ of the organization is the International Labour Conference. This is the legislative body of the International Labour Organization. It is called the International Forum for Discussion of World Labour, Social Problem, and International Labour Standards. The conference sets the broad policies of the ILO, and it's the only one that adopts its program and budget. The conference meets once a year, each year in Geneva. Earlier in the history of the organization, it used to meet elsewhere, but for now, for many years, it's been meeting in Geneva. The conference cannot be a conference unless the tripartism is respected, and every country must bring with it employer and worker delegates at the conference. So the composition of the national delegation is composed of two government officers, one employer representative, and one worker representative. If that is not respected, then the ILO says there's no national delegation for that particular country. These two social partners, as we call them, the employer and the worker, are a balancing act. As you can see, ILO is an intergovernmental organization, so the government pays dues. In this respect, it has two representatives, but it has to be balanced by the social partners. The beauty is that these social partners, the employers and worker delegates, vote independently of their government. And in many cases, they have voted against in a number of instances, the wills of the government as well. So there's that independence of the social partners. Now, below the conference, which meets once a year in Geneva, we have the governing body. This can be seen as the executive organ of the organization. The governing body is composed of 54 delegates, 28 governments, 14 employers, and 14 workers. I have to mention that there are 10 government seats that are permanently held by countries of industrial importance, as we call them. This includes United States, Germany, Italy, India, and the others as well. So these countries have a permanent seat in the governing body of the ILO. The others have to be elected every 3 years, taking into account geographical distribution. I wanted to mention that there's a mistake there. The last election of the governing body took place in the year 2022, not 2008. I'm sorry for that. But I wanted to bring on to the fore the importance of Nigeria in the ILO governing body. It's one of the very few countries that, as we speak, has a tripartite delegation at the governing body level. This doesn't happen many times. The government of Nigeria is a titular member of the governing body, as well as the worker delegate, Brother Ayuba Waba of the Nigeria Labour Congress. I know Ayuba retired last year, but once you are elected, either as a worker or as an employer, eventually that election is for the person. Not so much for the organization, at least until the expiry of the 3-year election period. The employer delegate at the governing body is not titular, is a substitute member. But I want to let you know that governing body of the ILO accepts both titular members as well as substitute members to be present. So in this case, we can say there's a full tripartite delegation from Nigeria at the governing body level into these areas. Now, the governing body meets 3 times a year, mainly in March and in November, but they also meet for 1 day in June, after the International Labour Conference. The governing body takes decision to give effect to the policies that have been adopted by the conference. It prepares the program and budget for submission to the conference. It is the governing body that elects the Director General, the only person in the ILO who is elected. Everybody else is a member of SAF. The last governing body elections were held in March 2022. I was still with the ILO, and I was still a key member of the staff that was running the secretariat at that time. And for the very first time, after 102 years, we have an African elected as Director General of the ILO. So Mr. Gilbert Humbo, the former Prime Minister of Togo, is now the Director General of the ILO for the next 5 years, renewable once. Now, let me skip this slide by just telling you that the ILO is a medium-range UN agency. It's not the biggest, but it's also not the smallest. As I was leaving the ILO, we had about 3,500 staff in 40 field offices around the world. The regional office for Africa is in Abidjan. And as I mentioned earlier on, Lagos provided the first venue for an African meeting in its office in Lagos. The ILO operates on 4 strategic objectives. The aims is to promote international labor standards, 2, employment creation, 3, strengthening social protection, and 4, social dialogue. These 4 strategic objectives is what is referred to as a decent work agenda of the ILO. Now, let me go into the substantive part of my presentation, which is about international labor standards. This being the very first webinar for Ellen, I thought I needed to be very raw and very simplistic in the way I'm going to present international labor standards. But as I also said, we have eminent speakers who are actually members of the organizations, of the institutions that I'll mention to this. So simply said, since the creation of the ILO in 1919, it has a total of 402 instruments, or what we can call standards in that particular way. Out of this 402, we can classify 190 as conventions, 6 as protocols, and 206 as recommendations. I'll explain this a little bit more for those that maybe may have questions, what is the difference between a convention, a protocol, and a recommendation. Now, I have to mention that not all the 402 instruments are valid today. Almost a third of them have been overtaken by events due to time, but also due to consolidation of thematic issues as well. One important factor here is that in the earlier years of the ILO, there were so many conventions that covered, for example, different elements of agriculture or the elimination of child labor. But recent conventions have consolidated all these different thematic areas into one major convention. So once a country has ratified the latest convention on a particular issue, the others become redundant. So in the numbers, they still appear, but some of them may be considered not up to date. Probably 14 conventions needs to have a special mention here. 10 that are considered fundamental conventions and 4 that are priority conventions. This is the top of the notch when it comes to the ILO instruments. The 10 core conventions are classified into 5 categories: elimination of forced labor, 2 conventions; freedom of association and the right to collective bargaining, 2 conventions; abolition of child labor, 2 conventions; elimination of discrimination in employment, 2 conventions; and finally, this, which was only adopted in 2022, is the category of occupational health and safety as core conventions as well. And here the ILO added Convention 155 on occupational health and safety, and Convention 187 also on occupational health and safety in agriculture as one of these. The beauty with Nigeria is that it has ratified all the 10 conventions. This is not seen in all countries. If I may talk, for example, for my own country, Kenya, Kenya is yet to ratify Convention 87. And this has been a discussion for many, many months and years as well. Now, about the 4 priority conventions, we have 4 that are very important: on employment policy, on labor inspection, and on tripartite consultation. Nigeria has ratified 2 of these, Convention 81 and Convention 144 on tripartite consultation. So this is a very good rating as well. Now, earlier on, I said sometimes we may wish to ask ourselves, what is the difference between a convention and a recommendation? This particular slide gives it in a very simplistic manner. They are all important, but a convention is open to ratification. You do not ratify a recommendation. A convention is an international treaty. In other words, once ratified, it is binding. A country must obey the minimum standards that are contained in that convention. A convention also involves dual obligations. Once you have ratified it, it's a national commitment to apply its principles. Secondly, you have to be willing to accept ILO supervision, which is at a higher level if you did not ratify that convention. So recommendation is not a national, it's not an international treaty. It's basically technical guidelines to complement the convention. It is not subject to ratification, but it supplements provisions contained in a referred convention as well. Now, how are international labor standards, both conventional ratifications made? What are the characteristics? 2 important characteristics. One is of universality. That standard must be applicable in any part of the world. So the ILO does not prepare standards for developing countries and for industrialized countries. No, universality is a very important phenomenon here. Secondly is the notion of flexibility. The standard are set in a spirit of realism and effectiveness. In other words, the standard must be applicable. It should not be a theory or a practice that is only difficult to attain. So one good example here is the Convention on the Elimination of Worst Forms of Child Labor. It gives limitations to developing countries to apply it over a period of time or with some bit of flexibility. So this is what are the major characteristics of the international labor standards. Colleagues, if I was to classify international labor standards, I'll put them into 10 categories. Maybe people will put it differently, but we can say the 402 standards can be classified into 10 categories: basic human rights, employment, social policy, labor administration, industrial relations, conditions of work, social security, employment of women, employment of children and young persons, as well as protection of special categories of workers. These could be workers in migrant situations. It could be workers in mines. It could be workers in different types of environments as well, including disabled workers or tribal workers too. So I won't be able to give you further details, but we can classify each of the conventions and recommendations into these trend categories. Let's pay a little bit more attention on these conventions and their ratification by Nigeria. As we are today, Nigeria has ratified 44 conventions. I've already mentioned earlier on that all the 10 core conventions or fundamental conventions have been ratified by the Federal Republic of Nigeria. 2 out of the 4 priority have also been ratified, and 32 other technical conventions. Now, I need to put a footnote here that out of the 44 conventions ratified by Nigeria, there are some that are no longer in force, along the same argument I had earlier. So only 28 of the 44 conventions are in force in Nigeria. 4 conventions have been denounced by the country. 8 instruments have been abrogated along the lines I had mentioned earlier, and 2 have only been ratified in the last 12 months. So they are not yet applicable for Nigeria until 1 full year has ended as well. So this is the situation for Nigeria. Moderator, I'll want to finalize my presentation by making a very brief presentation on supervisory mechanisms. The ILO has 2 ways of its supervising its international labor standards, a regular system as well as special procedures of supervision. Let me give you a quick overview of the regular supervision. Here, it involves examination of periodic reports on the application of each ratified convention and the participation of the social partners, such as the workers and employers in those particular comments. This is in line with Article 22 of the ILO Constitution. Now, very, very briefly, this periodicity of reports. Every ratified convention must be reported to the ILO every 3 years. And for other conventions, even if you've not ratified them, we still have to report. The frequency of this is every 5 years. And there are special bodies that actually examine these reports. So they are not just filed and forgotten. For example, the Committee of Experts and Application of Convention and Recommendations, the CEACR, a very important committee, and one of our panelists is a member of this committee. I'll talk about that shortly. And also the Conference Committee on Application of Standard, a very hyperactive committee that meets every year in June to look at this particular situation as well. Now, this committee on the Special Committee of Experts on Application of Conventions and Recommendation was created in 1926, composed of 20 eminent persons. And I'm glad to mention today here that Africa has 3 slots on this special committee. As already mentioned, Honorable Benedict Kanyip, the president of the National Industrial Court of Nigeria, is a member of this, and I'm glad to have him as part of our panel. From South Africa, we have Mr. Sandile Nkobo, and sorry, there are 4 members. From Cameroon, we have Paul Gerard Pugwe, and from Kenya, we have Ms. Irene Kashindi, an advocate of the High Court of Kenya, as members of this committee. Now, this picture just shows you an old photo in room number 1 at the ILO building in Geneva, where the committee ordinarily meets. This is actually called the President's Room, and the committee ordinarily meets here. Very, very restricted arrangements as well. Because of time, I wanted to show you the hyperactive committee, which I mentioned to you, is a tripartite committee. It is formed at every International Labour Conference and is called the Committee on Application of Standards. Nigeria has appeared in a very dramatic moment, I can tell you, under the Committee of Application of Standards on a number of issues as well. But that will be a subject of discussion in another moment. Now, other than those two those two regular committees, we also have special procedures of supervision. These include constitutional procedures, freedom of association procedures, we have representation procedures, we have complaints processes, and we also have freedom of association complaints. These are all mentioned in the Constitution of the ILO in different articles, and they are very, very important. Some of them are submitted by workers and employers. Some of them can be submitted by other parties as well. More information can be given into this particular regard. So I want to
Doctor, I would say you have,
finalize.
okay, I was going to say you have 5 minutes more, but thank you for moving on to the final stage.
Okay, thank you for that. I wanted to indicate to you the processes of how to do this, but I know there's not much time. I wanted to focus on the Committee on Freedom of Association. This is key in the work of ELAN and in the work of ILO as well. I wanted to mention that since its creation over 70 years ago, the Committee on Freedom of Association has examined over 3,300 cases. And the beauty is that it has brought forward very good successes. We can indicate that more than 60 countries have acted on the recommendations of the Committee on Freedom of Association, just as I positively mentioned about the beautiful work done by the other committees as well. Now, Africa has had 417 cases from CFA, 7 of these cases from Nigeria. Some of the very peculiar cases from Nigeria are case 2267 and 2432, which were brought by the Association of Staff of the University in Nigeria, relating to issues of strike, freedom of association, as well as lack of consultation with workers when the government of Nigeria was changing the law on tripartite consultations as well. Now, this final slide, my moderator, summarizes the ILO supervision processes, which we have mentioned, but I can't go into details. I can summarize it into 2 levels. One, regular supervision, and some of our eminent personalities will speak about it today, and also the special supervision. This is very particularly important for ELAN and ILO when it comes to a number of litigation processes and how the ILO can actually handle that. So I'll just leave you with this particular slide and express my sincere appreciation to the moderator and to the organizers for having me here today. Thank you so much.
Thank you, Dr. Mwamazingu. The wealth of experience is clear from the presentation, and we're grateful for you spending time with us here today. I would say that questions can be asked in the chat room and we would collate them afterwards. I would now ask my Lord, the Honorable Justice Kanyip, to give us a few general remarks on the ILO system, both as from the experience of a judicial officer interpreting and applying the law, as well as a member of the committee of experts who looks at it from the international rulemaking and supervisory perspective. So I'll be grateful to my Lord for some general remarks, also considering and bearing in mind the extent to which these international labor standards reflect or impact the socio-economic realities of Nigeria. I'm grateful, my Lord.
Thank you very much. I must thank the paper presenter for making everybody's work quite easy. The presentation was very nice, and like you said, no matter how associated you are with the ILO, you always get to learn something new each time issues of ILO are being discussed. Just one or two quick points. The presenter said the representation for Africa is actually 5 now. I think he missed out North Africa. And then Professor Puge just finished his term. And I think there's an advert that is already out to fill that vacancy. So Africa is actually represented at the Committee of Experts by 5 representatives, not 4. That makes it pretty nice. And I'm just 2 years old at the committee. I started in 2022, had my second meeting last year. So I'm into the 3rd year. After this year, if they find my work good enough, they might renew it for another 3 years, up to a maximum of 15 years. One of the very first things I was able to discover when I went there is that there's a huge gap between the reality of labor law and practice in Nigeria and what the international standards require. In quite a number of respects, I discovered that some of the things we're doing were really not in accordance with the ILO standards. Of course, there are areas in the ILO standards themselves that are being queried. Right now, there is a question that has been sent to the International Court of Justice at The Hague to interpret whether by Conventions 87 and 98, the right to strike is part of those conventions. The stance of the Committee of Experts had always been that though these conventions did not name the right to strike by name in the conventions, but they are imputed in terms of the jurisprudence. The employer group had always questioned that particular stance, and at the last governing board meeting, despite differences in opinion, the generally accepted view was that they should refer that question to the International Court of Justice, because if you look at the ILO Constitution, when it comes to questions of law, the final arbiter on that question is the International Court of Justice. So that question is currently pending at the International Court of Justice, and they have already asked interested parties. And by interested parties, they have already determined the criteria for determining who is an interested party, and one of which is that a country that has ratified Conventions 87 and 98 is an interested party and is permitted to send in their memo as to which stance they are taking, whether to support the view that the right to strike is inbuilt in Conventions 87 and 98, or to oppose that particular stance. What this means for us in Nigeria, for instance, is that within our local jurisprudence, at least within the National Industrial Code, we have had to use ILO literature, which predominantly stemmed from the Committee of Experts on the application of conventions and recommendations, jurisprudence on the right to strike, to interpret, given our mandate to apply international best practices, to interpret the right to strike in Nigeria in accordance with the international jurisprudence as laid down by the ILO itself. What it means now is that if the International Court of Justice, for instance, decides that the right to strike is not part of Conventions 87 and 90, it means back home in Nigeria, we will have to re-evaluate our decisions that have been given on the basis of the stance that it is part of Convention 87 98. So the outcome of that particular decision at the ICJ is as much important for the ILO as it is for us in Nigeria, given our constitutional mandate that we should apply international best practices. This aside, you would find that a point made by the paper presenter a while ago was that the international standards have the character of universality and flexibility. Yes, there is universality in the sense that we don't make standards for developing countries separate from standards for developers. But of course, you know, we are all at a personal level. When I was being interviewed for membership of the committee of experts, I was asked what I was going to bring to the table. And my answer was that all through my life, I have been working in areas of law and have come to understand that the law treats economically disadvantaged people separately from those who are more advantaged. Whether it is consumer protection, whether it is employer-employee relations, whether it is bank customer relationship, whether it is landlord-tenant, whether it is taxpayer, taxman, so long as you are economically disadvantaged, by which I mean that the bargaining power you exude is not as much as that powerful economic group, there is this thing about the law which disproportionately applies to you. Each time you go to court, for instance, it's not always the case that the economically disadvantaged person will win. So I said that was at the level of individuals in terms of application of law, but I was more interested to now understand whether the same logic applies at the international level. In other words, in applying some of these rules, some of these laws, some of these principles, is there a way these principles are understood differently by developed countries from developing countries? Remember, I have said that the standards were not made with any distinctions in mind as to whether you are a developing economy or a developed economy. But I'm still curious, in reality, does that distinction not matter? Is a question I have asked even at meetings at the committee of experts. And for me, it's an ongoing question for discussion. And time will tell whether we will, despite the fact that the standards were not made with those distinctions in mind, whether the reality of the situation in terms of the practical applicability. Because one thing I discovered is this: the cost of having to apply international standards ratified by countries is disproportionate. It's higher on developing countries than it is countries. Whether or not that should be a factor to be taken into account, I think is something that time will tell. I said, it's an ongoing process and we'll wait to see how. I just want to stop at this point, knowing that we don't have all the time today.
Thank you very much, my lord. Very insightful comments, which we appreciate. I'll now move on to Professor Agomo to ask again for some general remarks, but bearing in mind that these international labor standards, although they've been in force or a source of law in Nigeria for many years, and then they were concretized with the constitutional amendments or they were galvanized, I would say, in 2010. But we still find so many lawyers holding on to the old principles as if they are not aware of the move to rely on international standards. So I would ask what the Professor Agomo would say can be done to get the knowledge of lawyers to where it should be, especially the new lawyers in training.
Thank you, moderator. And I want to thank Ellen and partners for inviting me to be part of this webinar. International labor standards and its application is my passion. And I thank the paper presenter for such a lucid and a simplistic way of bringing out the points, the issues. Like my Lord Justice Kanyep said, you can always learn something. And from his own comments too, looking at the social, the economic cost of implementation, you also learn something new. Now, part of what I'm asked to talk about is, it said, even though Nigeria, as it were, has been applying international labor standards and has become part of us since 2010 by virtue of the constitutional amendment.
Oh, okay. Thank you.
By way of the constitutional amendment, said, do you think whether the importation of foreign law has come to stay? I wanted to make the point that I don't understand what is meant by foreign law. Is it that international labor standards are considered as foreign law in Nigeria, or what? In that case, the presentation has made it abundantly clear that ILS, or international labor standards, they are not foreign law. And we've been reminded again of how they come to be. The tripartism, the workers, the government, the employers taking part in the legislative process. And so I would say that the influence of the ILO augurs well for domestic lawmaking, provided those special circumstances affecting national countries are taken into consideration.
Professor Agomo is muted.
Prof, you are muted, man.
Wow, but I muted myself. Somebody must have muted me. Can you hear me now?
Yes, we can hear you. Yes.
Okay, I was saying that as an educator, what can be done to popularize or to enlighten or to educate lawyers to become aware of international labor standards and to imbibe it in the application. The issue is one of habits die hard. Let me put it that way. Habits die hard. We are so deep and steeped in the common law system that we think is sacrosanct. But beyond that is the issue that labor and employment law, labor law is not a compulsory course in the universities. It's an optional course. And not many people take it. And I would say that, for example, my view of it, my whole attitude towards labor law and what it should be or what it contains changed in 2001 when I had the privilege of attending the international labor standards for lawyers, legal educators, judges, and senior trade union officials in 2001. And I came back a different person, a changed person. And I thank God that Professor Diogo, who was the anchor person, allowed me and gave me a free hand to change the whole content of our labor law, both at the undergraduate and the postgraduate level. That happened because I had been enlightened, I had been educated. So there is need for this education, there is need for this sustained training so that lawyers will become aware of international labor standards. It's a part and parcel of Nigerian law. It has been there. The Labor Act, for example, embodies some of these conventions. It's there. But it's a question of our changing our orientation and not thinking that it's foreign law or that's something that's been made and imposed on us. It is not. It's something that we are part and parcel of. And so there's need for orientation. The answer for me is education, training, familiarization. So constant from the lowest level, that is at the university. In fact, if labor law can be introduced at the lowest level from 200 level instead of living normally at the last year, it's very, very important. And of course, those in the judiciary, the higher level, National Industrial Court, they're all aware of it. So it's very, very important that all should be educated and enlightened. There is no other way other than educating lawyers. Thank you.
Thank you very much, Professor Agomo. I think you've made some very interesting remarks and made some suggestions on how to get things better, create better awareness. I'll just ask one question of Dr. Nwamazingo. We've not received any questions from the audience, but I would ask a question that sort of draws from Prof's remarks, which is, so this perception, when we have these foreign organizations based in the UN, under the UN system, yes, although Africa has 5 representatives, but there is sometimes this perception that these are standards set by, or standards set by developing or developed countries, rather more advanced economies who have conquered certain challenges that developing countries are still dealing with. Now, what would you say is the way to maybe counter that perception that these international labor standards are foreign things that are being maybe projected to developing countries by the developed world?
Thank you, our moderator. That's a very valid question. I mean, even for us who worked with the ILO inside, we have faced this type of questions from a number of parties before. But I think the best answer was already given by the professor who just spoke a short while ago, Professor Agomo, who said by her attending some of the programs organized by the ILO and also by the International Training Center of the ILO, you come to realize that that particular perception may not be correct. And I'll want to support her in that particular regard. For some of us who have been heavily involved in the preparations of the agenda when it comes to standard setting, we know how intensive it is. Every particular standard normally takes 2 years, but it's a process that will have begun 3, 4, 5, 6 years ago through the governing body processes. And in this particular regard, there's a wide dissemination of the intention to come up with a standard. Right now, there's a lot of talk promoted by employers and also by workers that we may need to have a standard on the recent challenges caused by climate change. The world of work has changed dramatically. This is not just an issue of the industrialized countries. It also affects us in Africa and also in other developing regions. And unions and employers from these other regions do concur that a particular standard may be necessary to protect workers and others working under extreme weather conditions. Now, for that process to be completed, the ILO will send questionnaires to all the 187 member states, and they'll be obliged to respond. Now, it is this response that the office, the secretariat, will develop a paper for submission to the governing body and eventually to the conference. And everybody's idea will be incorporated into that. When it comes to the actual International Labour Conference discussion on that particular standard setting, all the member states have an equal vote. So, Mr. Moderator, is just to answer that the perception that the standards are meant only for developing countries may not hold true if we follow the due process of what the organization does.
Thank you very much, Dr. Mwamazingo. I will just ask, I see an audience hand up, but I will just ask my Lord one question, and following that, I will take the question from the audience member. My Lord mentioned that when you started working with the ILO, you noticed some difference in, I mean, or you expected that developing countries who have unequal economic standing, would that difference ought to be recognized? But on a more general note, I'm going to ask my Lord to consider or to comment on what difference, if any, since these standards have begun to be enforced in Nigerian courts, has my Lord noticed improvement in the kind of complaints that plaintiffs bring? So is there an improvement in treatment of workers by reason which can be attributed to enforcement of ILO standards in Nigeria?
Thank you. Let me just give a simple example. Under the Trade Unions Act, there is a provision that says you can't register a trade union once there is in existence a trade union in that field, which means ASU, for instance, you cannot register another academic union within the set. But when you look at the literature from ILO, it says no. Principle is trade union pluralism, not trade union monopoly, which means the fact that there is in existence a trade union in an enterprise does not hinder the registration of another. So based on this ILO literature, for instance, sometime last year, I was able to order the registration of an organization called the Law Officers Association of Nigeria, which is composed of law officers in ministries of justice, both at the states and the government. The denial, they were denied return, and the reason given was that there was JUSUN in existence. And that in any event, there are other senior staff associations, like the Senior Staff Association of Civil Service, which they can join. And clarity that these unions can't cater to. They came out, and based on the new jurisprudence that we now came across in our access to ILO now, where government, you don't have any valid reason to say you are not going to register this body. And so we gave the order, and I think, was it some few days ago, the motion filed for contempt happened because according to the law, complied, and they have been issued with a certificate of registration. The same thing with another case like before me was one relating to of labor setting up a committee for a union. And you know, the ILO is strict about non-interference when it comes.
Seems we lost it seems the connection may have broke. Please bear with us. Let's give a bit of time if my Lord would reestablish connection with us. Okay.
Hello?
Yes, we have you back. We can hear you and see you, my Lord.
I don't know whether it was the internet service or not. Anyway, the point I'm trying to make is that within of ILO jurisprudence, through administrative action, interference is the rule. And non-interference has been interpreted to also include the ban against government setting up caretaker committees for trade unions. So one of such cases came before me, and of course I gave the order that the caretaker committee set up was null and void, illegal and unlawful. So all of this is possible because of my relationship in terms of access to the committee of experts and the literature that stems with it. A point I wasn't able to make initially. The committee works at two levels. Apart from having to look at how countries that have ratified conventions apply them. Sometimes, and this happens every year, an issue is given to the committee by the governing board to look into in terms of its law, practical implementation, and so on. For 2024, we are going to be looking into, we call it general survey. We are going to be looking into employment injury compensation. Last year, we looked into labor administration. In 2022, we looked into achieving gender equality at work. So every year, a theme is given, and the committee of experts reviews government literature and other literature submitted by the other stakeholders, workers and employers, and then comes up with something like a discussion of the law relating to that general subject matter. So right now, we are hoping this year, we are going to come out with something on employment injury. So apart from holding countries liable or holding them against the conventions they ratified, we also do general surveys on the law relating to a subject matter. It is in relation to this general survey that the committee of experts some years back came to the conclusion that the right to strike is an integral part of Conventions 87 and 98. But like I pointed out, the matter is before the ICJ. We are waiting for them to tell us whether that position is a correct statement of the law as it is or it is not. There's one point I need to make, I think, relating to the general question that was asked as to whether we have imported international law and whatever. I actually understand the concerns people make. Yes, Nigeria was part of the process, must have been part of the process that generated some of these standards. At least Convention 190 that we ratified a while ago, which the paper presenter referred to. Nigeria was part of the process. So Nigeria cannot claim that this is a foreign-based law and so on. I think the context in which people are scared or afraid is that the interpretation of some of the standards, you can imagine a standard that was made before the Second World War being interpreted today based on circumstances that were unheard of as at the time it was actually made. So people are scared that, and I feel for them, that we are faced with a situation where those who determine the value system that should regulate us, I go back to the point I made, are essentially people who command greater economic power. Those of us who do not command greater economic power have lesser voices when it comes to determining the values against which some of these standards are interpreted. I have seen some, I can't give you exact names now, but I have seen some ILO standards with clauses that allow countries circumstances. There are some standards that give to have standards like that. Of course, the claim that you are being regulated by a foreign value system will not hold ground. But that does not take away the fear. And I sorry to bring it up here. If you raise an issue relating to LGBT, for instance, at the level of the ILO, you are going to have diverse opinions, diverse differences. In fact, at a point, a whole regional bloc threatened not to even be part of ILO or to fund it if those were the issues that are going to be brought on the table. So there are these fears that are there. You can't run away from it. We have to face them and look at them squarely. Thank you.
I thank my Lord for, again, always enlightening remarks. I will just say we're far gone into the day, and I will take the question from the audience. Mr. Bashman, can you?
Yeah, thank you, Shehu. Coincidentally, my Lord has spoken my mind. I quite agree with Brother Mohammed that the ILO is one of the most democratic structure in the UN system that operate a tripartite system that you see workers, employee, and government collaborating to set up standard. But we should not lose the fact that there's also this global south, global north dichotomy. For instance, we are in the process of having a convention for platform workers. I can affirm, working with the international organization, that workers' organization, employers rep are also part of the standard making process. But we can't overrule, even from the structure, the existing structure of ILO, permit me to say, is also very faulty. We have some 10 states or economy that have been classified as industrially significant. How significant are these economic in present day reality? So I agreed, they are very democratic, but at the same time, we cannot just go to sleep that all is well. So we can't take all that is coming. There's also a need for ILO as a standard making body to also do a rethink, especially looking at even its structure. It's scary to some of us. So I think that's the submission, but I'm happy that my Lord actually expatiated, especially on the issue of LGBTQ. But just to say that I'm not anti-LGBTQ, but I just know it's on Africa. So let me just make that submission. Thank you.
Thank you, Bashman. I have, again, no questions from the audience. I have one last question that I would like Professor Agomo to express some views about, and then we can move on to the closing remarks. So, Professor Agomo, I would like to hear your perception. I mean, there's some views by some people that with the extensive scope of the ILO standards and with the powers of the court to enforce them, it seems almost as if there is no need for any more domestic legislation on labor in Nigeria. And for some strange reason, indeed, the domestic legislation in Nigeria relating to labor and employment has also been stagnant. But so the courts will draw from ILO and international standards to fill those gaps, as it seems. But my Lord, I mean, Professor Agomo, do you agree with this? And what are your thoughts about the perception that the international standards would render domestic legislation of lesser importance?
Thank you very much. I don't share that view. I do not share the view that international labor standards will render domestic legislation less effective. My view is that international labor standards have become, call it the standard setting mechanism, that it says the minimum standards by which you can evaluate domestic legislation. We live in a globalized world. We have the global supply chain, so we can't pretend that our legislation should be anything less than the minimum standards. And that's why, for me, the Third Alteration Act is so critical, it's so key, because it's so comprehensive, and it also provides the avenues for incorporating and implementing local legislation, if I may call it that, but using the international labor standards as the parameter for measuring its humaneness, its efficacy, the concept of decent work. The problem we have, I think, is that we think that issues relating to labor should be left to the domestic domain, and so there should be no interference. But there is, it's collapsed. The world of work is collapsed. So you can't pretend that we are in an island on our own. I fully agree with my Lord about the special issues. That's also why when we look at individual standards, it also provides in many of them, I said, insofar as local conditions permit. So it's still within the powers of the domestic enforcing bodies to be able to apply local standards, but using international standards as the floor, the basic minimum. For me, it is not negotiable. It is not, it is an irreducible minimum, but subject to our local circumstances, which must be taken into consideration. I agree with the comments made by Bashman. I also agree with the comment made by my Lord, Justice Kanye. But I am firmly of the view that international labor standards give flesh to national labor standards, and you can't do without them. We can't do without, because we are part of, we should be engaged more robustly to be able to bring to the table those issues that are peculiar to developing countries, obtaining countries, so that at the end of the day, if it doesn't qualify for convention, let it go to recommendation. But we must continue to press forward. I don't think we can go back to become an island. Thank you.
Thank you, Prof.
Let me add my voice to that, please.
As the court pleases.
Let me add my voice to that. A day or two ago, somebody asked me something similar on this, and I asked a simple question. Because we're in a globalized world, we have multinationals everywhere. And I asked him, how would you feel if the labor standards of a multinational company in Nigeria were less than the labor standards of that same body in its home country? And he kept quiet. I said, see, the role of National Industrial Court, for instance, of course, subject to what the lawyers bring, is to ascertain and ensure that these standards are uniform. If country A applies a favorable standard in its home country, but comes to country B because of lax regulation, lax laws, or inadequate laws, tries to seize advantage and then imposes a lower standard, for God's sake, there should be somebody to say, no, 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 this can't happen here. So to answer that question more directly, international standards do not make domestic legislation unnecessary. You still need domestic legislation. Ours is a special problem because the Labor Act we have today was an act made in 1974. And since then, it has not undergone any major change. When the opportunity came to do the third alteration, and taking a cue from the queries Nigeria get every year from the Committee of Experts as to our non-implementation of ratified conventions, we suggested to Parliament that the National Assembly give NIC the power to apply international standards in terms of the conventions ratified by Nigeria. This way, we are killing two birds with one stone. Apart from bringing international standards to the fray, we are also indirectly replying ILO that, look, each time you query us on an international standard ratified by Nigeria, remember, Everybody, including employees, have the right to go to court and hold us responsible. I gave you a simple example a while ago. Law Officers Association of Nigeria was not registered. That could have earned Nigeria a query before the committee of experts, if that is brought to their attention. But they came to court, got a judgment, and government has registered them and issued them with a certificate of registration. All of that is possible because the Constitution says NIC, apply international standards when you are adjudicating. So if you bring a case that falls within the international standards ratified by Nigeria, and you get a verdict and it is implemented, where else would you say something has gone wrong? So look at the issue of outsourcing, for instance. Even within the structure of ILO, there is no comprehensive standard on outsourcing. So you cannot say domestic legislation on outsourcing is unnecessary. It is necessary, but pending when that domestic legislation comes, you have to have an institution that can, on a case-by-case basis, begin to bring some of these things to the fray. Some few days ago, one of my staff brought to my attention comments people were making on social media about NIC. And one of the comments that struck me was a comment that said, NIC has been struggling to bring the outdated labor laws of Nigeria within the framework of the national labor standards, kind of making it modernized. If the legislation had made it modernized, we wouldn't be struggling. But the point is that, whether we like it or not, Nigeria is no longer the 1974 Nigeria. When the Labor Act was made in 1974, there were a lot of issues that were not anticipated. Today, this Labor Act cannot treat these issues. Our saving grace is that general provision in the third alteration that says apply international standards. Because now we can hold on to provisions of this 1974 Act to the standards of today. Of course, even Convention 87 that is said to be a core convention and so on, there are about 38 countries in the world today that are yet to ratify it. The paper presenter told us a while ago that Kenya has not yet ratified Convention 87. So it's not as if there's compulsion on anybody. Countries choose which standards to ratify. If you ratify, you are held to it. And the Constitution says, Nigeria, we are going to hold you to the standards you ratified. If we went out of our way to ratify certain standards, and the Constitution says, hold the country responsible to it, how can anybody complain? Thank you.
I'm grateful to my Lord for these very enlightening remarks. I have one member of the audience who wants to make a contribution. I'll just say Mr. Oh, I don't know if it's Miss, but Olawale Ajay. Please, you can.
Thank you very much, Mr. Moderator. With due respects to my Lord and to the assemblage of distinguished persons. Actually, I was sort of provoked by the last question to just put in the comment that it is certainly anomalous to leave to the NIC the duty of tripartite consideration and legislation. So it's quite anomalous that the labor laws in Nigeria are not being updated, and that the regulatory agency is sort of missing in the action. And this situation should not be allowed to continue, particularly because labor law has a very great intersection in terms of commercial business laws and so on, and in terms of national competitiveness. It's of first water that this situation should be changed, particularly in view of the African Continental Free Trade Agreement and Nigeria's, I hope, wish to loom large across the continent. It should actually be setting standards, or at least making sure that the African continent is keeping to minimum standards. And I know those standards have been developed even at after. So I think we should cry out, particularly the practicing bar, to influence legislation and to make sure that as far as possible, of course, there'll always be lag, but as far as possible, the legislation should be contemporary, and regulatory agency, particularly the Ministry of Labor, must be brought up to the mark. Thank you.
Thank you very much for your contribution, Mr. Ajay. I see a number of the honorable judges of the Industrial Court, although we're pressed for time, but if any, I see my Lord Honorable Justice Peters, my Lord Justice Oji, Justice Obaseki Osagai, if any of the lords are inclined to make any comments, we'll be happy to hear from you. Otherwise, I would hand it over to Dr. Bamu for closing remarks. Okay, thank you, Dr. Bamu. I would say, please make the closing remarks. And
Thank you very much. Thank you. I'm actually on my way to meet colleagues, including Jackie Wamai, who is the representative for Africa at the at ILO. So I think on behalf of the African Labour Law Society and its members, we would like to just extend our heartfelt thanks that we have had this really, really enlightening presentation and a very robust discussion on some of the very, very topical issues around labor law, and I think international labor law. And I think the beauty of it is that this is just the beginning. So the best is yet to come. And I think the more we have these conversations, the more we can elevate really our voices in these international and global debates of labor law of the day. On behalf of the Management Committee of the African Labour Law Society, I'd like to advise the members of ILAN and others present here that you are welcome to the 6th conference of the African Labour Law Society, where topics like this and discussions like this are what we really want to get down and do. And we are having this conference in Johannesburg in South Africa. I think that the information about the call for papers, information about registration will be distributed by the leadership of ILAN. We look forward to your participation. And really, I think there's no better time for us to be coming together than this so that we can continue with these debates and with this engagement. With that, I thank you very much for this opportunity and wish you a good weekend.
Thank you, everyone. I will just note that the penultimate speaker is Professor Ajay of the Lagos Business School, a leading author on consumer protection in Nigeria. I thank the judges who have made the time here today and all the members of the audience, and wishing you a good evening, and bye-bye, everyone.
Thank you, my lord. Bye.